Morning, everyone. I hope everyone's doing well today. Um, Probably most of you know me, but for those of you who don't, I'm Ann Lavelle. I'm the CTR compliance specialist. A little background on me. First and foremost is I'm Irish, so happy early St. Patrick's Day to everybody. That's the most important thing I'm saying today. Luck of the Irish to everybody. Second, I was an attorney, a labor and employment attorney for almost 25 years. And I retired to spend more time with my family, but I knew CTR from that life, and I always enjoyed doing the trainings. So here I am because I think these can be very interesting, and I'm very excited about today, which may show that I need to get a life. But we're going to have some audience participation, even though this is a webinar today. So everybody get ready, find your chat buttons on the Zoom, and hopefully people can chime in. And of course, we always welcome questions throughout the seminar, or webinar. And if you have questions, please feel free to put it in the Q&A, and I will get to everybody's questions the best I can as we go along here. So, Fair Labor Standards Act, you just can't get enough of the FLSA. Today, this webinar sort of assumes that you know. If the chat is disabled, just put it in the Q&A. I'm not sure why the chat's disabled. Somebody sent a message saying the chat's disabled. Just put any answers or questions in the Q&A. I am seeing that, so that will work. I am not a technical guru, unfortunately, so we'll go with the Q&A. So you can't get enough of the FLSA. This webinar today kind of presumes that you at least have some knowledge of the FLSA. We have done a lot of webinars on what are the requirements, how do you define the executive exemption, for instance. We'll briefly touch on that today. If you want a more in-depth experience, though, we've done other webinars that talk about sort of the basics of the FLSA, of what is a salary basis, what are the exemptions, etc. Today, we're going to look at this from a court perspective of actual cases that went before different courts and how they viewed the facts of the case as applying it to the legal standard of what constitutes an administrative exempt employee. So I think this will be interesting. We'll go from there. We are recording this, so if you miss something or want to share it with somebody or whatever, we do record it, and we put all of the PowerPoint slides on the web for you guys so you can see this. It does take us a little bit of time to do that, so probably by tomorrow, because we have a lot of people out for a seminar, but they will show up. So give us a little time and you will have this whole PowerPoint deck as well as the actual webinar that you can look back on. As we do with every one of these webinars, which are generally the second Thursday of the month. Although next month we are doing a seminar live and in person down at PNC Park. That is a great venue. I've spoken there a number of times. It'll get you ready for baseball season, just looking out on the field. So come join us. That'll be a lot of fun. We always try to provide a little bit of legislative update if there's anything interesting or boring going on with the courts or Congress or anybody like that. And so there's two things that are at play right at the moment. One is a court just blocked what's known as the joint employer rule from taking effect. This affects companies where, you maybe have a shared employee or a temporary worker or something like that. There had been a new rule coming out to determine what constitutes a joint employer relationship. As with all of these regulations and rules, you almost always get a court challenge because one side of the aisle or the other is unhappy with it. We had a court challenge. It was in a very conservative court system in our country, and they blocked the rule. It's going to be appealed, but we'll see what happens. That doesn't mean joint employment doesn't exist right now. It just means that these rules, which would have sort of broadened the net of who is a joint employer, are on hold. Independent contractor misclassification rule is in effect, though. That's something we have harped on, or I've harped on at least, in other webinars of being very careful with that. This is a U.S. Department of Labor priority because they think there's too many independent contractors out there that should be classified as employees. If you're running around with a bunch of 1099 workers, or worse, if you're calling them 1099 employees, because there is no such thing as a 1099 employee, look at this new rule. We've talked about it in other webinars. You probably have a problem if you have a bunch of 1099 workers that probably should be employees. So take a close look at that. Okay, jumping into today's topic, the FLSA and the court system. Why do we care? That's the first question. Well, when we look at misclassification of exempt workers. So exempt workers, just for a brief review, are those that don't have to get overtime. You can make them work 100 hours a week. They may quit if you do that, but you can do it. And you pay them a set salary, which right now is about $684. It may go up to over $1,000, depending on how things play out. And we've done a webinar on that too. But they're supposed to meet one of the exemption tests in order to not be paid overtime. And the three primary exemptions are the executive, administrative, and professional exemptions. And you can see the statistics here on this slide that when we look at this, the U.S. Department of Labor, the DOL, each year has enforcement actions with respect to this topic. And the best statistics we have is that the DOL collects somewhere between 200 and 240 million a year from employers who have messed up, right? About 200,000 employees a year. And that's the back wages, penalties, interest, whatever. And some of you may be sitting there saying, well, that's sticker shock. I don't like that. Keep in mind, that's just the DOL compliance initiatives. You can also get lawsuits on these. And the rough estimate is each year there's about 6,000 lawsuits in federal court across the country, and that the private settlements from those are topping out over a few hundred million. So we should care because it's an expensive price tag. We want to make sure we got this right. It's very difficult to get this right in some cases. Some employees, it's obvious that they're exempt, but there's a ton of employees where you say, I'm not sure. And that's kind of the employees we're going to focus on today. There's also state wage laws, right, that also add to this. Investigations and lawsuits that come in at a similar amount. And something that's important, we'll hit on it today. I think we can't emphasize it enough. We've talked about it before. These claims are usually not insured. So if you have something that's called Employment Practices Liability Insurance, EPLI, and I hope you all do, because that's a great insurance. And I promise you, I'm not getting some sort of kickback from the insurance companies for saying that. That protects you if you get sued for discrimination or harassment or something along those lines. Because that's usually not a question of if you'll get sued, but when. Great coverage to have. That usually doesn't cover wage and hour claims unless you have a specific rider added to your policy for this. And even then, it usually only covers the attorney's fees in these claims, which is better than nothing, right? Because attorneys can be expensive, but it doesn't cover the underlying amount of wages owed to the employees if you're found to be in violation. So that's why we should care. So let's jump in. Plus, it's the right thing to do, right? The administrative exemption, again, we've covered this in more detail, but just as a brief review. One of the most puzzling exemptions out there is this one, because people hear administrative, and unfortunately, sometimes the first thing they think of is, oh, that's like the administrative assistant. Absolutely not. That person's never going to qualify, or almost never. I guess I should never say never, for this exemption. That's not what this means. We're not talking about administrative staff at all. We're talking about somebody who's paid the salary basis, $684 a week. Their primary duty, and this is critical, is non-manual work related to the management or general business operations of the employer. And the person has to have sufficient independent sort of judgment and discretion in their job to decide what they want to do. How do you apply that to your employees? Has anybody ever had a problem applying that? You can use the Q&A. It's a really common issue. So when I used to practice, one of the things we would do for some of our clients who requested it is sort of an exemption review, right? We would go through their different job descriptions and positions and say, look, based on this, these people are clearly exempt. Based on this, these people are clearly non-exempt. Here's your gray area. Here's your risk. Here's some things you can do to sort of shore up who's exempt or non-exempt, or to change it to lower your risk. And we'll talk about some of the things you can do to sort of change to lower your risk if you think you have a gray area employee. And I can almost guarantee everybody on this webinar has a gray area employee. It's just impossible to get away from that. So moving on. Okay, nobody responded to the Q&A. Apparently nobody's got a gray area employee who's ever had this challenge. But nonetheless, we're going to push forward. Our first case, and let's just talk about the court system for 1 second here. Most of the cases that we're going to talk about today come from the circuit courts. So just as a refresher of how our court system is set up, most of these cases are federal cases in the federal court system. And the way that system works is it's district courts, circuit courts, and then the Supreme Court, U.S. Supreme Court. So the circuit courts are one step below the Supreme Court. It's about as high as you can get in this country because most cases don't go up to the Supreme Court. There's also different circuits within the country. For those of you in Pennsylvania, we are in the 3rd Circuit. This case, Fowler, is out of the 11th Circuit. That's for folks in Florida, Alabama, and Georgia. But just because they are in the 11th Circuit is in Florida, Alabama, or Georgia, doesn't mean we can say, oh, forget them. Those Southerners, we don't have to worry about them. The other courts look to their sister courts for precedent and for persuasive precedent and often follow each other. So just because it's not in our circuit doesn't mean we can ignore it. So anyway, this company did something that I never even knew existed. They were a business who had clients who were broadband customers, essentially. And they would go out and look at the broadband infrastructure systems of their clients to check on damage to it and to assess how the damage occurred, what happened, was it malicious, was it not malicious, who was liable, and then calculate the cost of repairs. I had no idea that this job even existed. The employees who did this were property damage investigators. So they were classified as exempt under the administrative exemption. Why do we think the employer classified them that way? Well, let's go back to our test. They were paid a salary. That was not at issue here, right? Sometimes that's at issue, but in most of these cases we're talking about today, not at issue. Were they exercising independent discretion and judgment? So if you look at this, do you think they were exercising independent discretion and judgment? They're out there in the field determining the source of the damage, who was liable, and how much it would cost. Anybody want to put their hand up or put something in the Q&A? Make me feel good that people are actually listening. That this sounds like independent discretion and judgment. Anybody think it does? The employer thought it did. And okay, somebody's raising their hands. I appreciate that very much. Yeah, if I was looking at this, hey, when I used to practice, I don't practice anymore. Other people were saying, yes, I agree. To me, this looks like independent discretion and judgment. As a layperson, I wouldn't be able to go out and look at somebody's broadband infrastructure and come up with an idea as to, who in the world did this and why they did it, and who knows, how much it's going to cost to repair this. So the employer thought, so somebody said, it looks like it, but they aren't in charge. So that's an interesting comment. Do they have to be in charge? do they have to have the final say on whether the cost to repair this crazy broadband equipment was $100,000 or $1 million or $1,000? I have no idea how much it costs to repair broadband equipment. So that's a good question. What do we think about the second prong of the test, which says they have to be involved? And let's go back a screen if I can. I have multiple screens going here, so it gives me 1 second here to go back. There we go. That what they are doing is office or non-manual work. I'd say, yeah, that's probably true. It's not like they're on a production line. Is it directly related to the management or general business operations of the employer? Would you say yes to that? All this company did was look at their clients' broadband systems. That was their whole business. So if I looked at that, I would say, yeah, that looks like their general business, maybe not management, but the general business operations. That looks like it to me. Okay. The district court, remember we got district, circuit, Supreme Court. The district court for this concluded that they were exempt administrative workers because they performed work that was important and significant to the management or general business operations of OSP, that the employer. To me, that makes a lot of sense. Again, this got appealed, as do many cases, because this is not just one employee who's upset with the company. This is a class action lawsuit. So all of the property damage investigators who ever worked for this company for the past 3 years from the time this lawsuit was filed are involved in this, and potentially the company owes money to them, which is a big price tag. I'll also say by the time you get to the circuit court level, you have paid a lot to your attorneys. And that's one of the reasons, if you're thinking about insurance, even if it doesn't cover the wage payment to these employees, if it covers the attorney's fees, that is something, because by the time you get to the circuit court, which is where this went, because the employees appealed, they said, we disagree. You have several $100,000 in attorney's fees alone into this case. So who thinks the circuit court agreed with the district court? Anybody? Are they still exempt, or what do we think? This is, feel free to do the chat. I know. Okay, so somebody said, okay, great. We have 2 great comments here. And I love this. I wish this was a seminar. It'd be so much easier. But one person said, what about the professional exemption? So we'll get to some cases about the professional exemption. These folks did not necessarily have college degrees or any other similar degree. Apparently, you can learn this on the job and with a little bit of training, and that's not going to qualify you for the professional exemption. Somebody else said, well, if someone is dispatching them, then they shouldn't be exempt. So that's a good point as well. And we don't know from the case whether someone was dispatching them. I would say they probably were. They were probably saying, hey, today you go to XYZ location for customer ABC. They're reporting a problem. Let's see if they have damage there. I don't think being dispatched is necessarily determinative, but, okay, I love this comment. Thank you. The circuit court's going to disagree, or we wouldn't be discussing this, with a little smiley face. Yes, that's correct. Okay. The circuit court said, and if I can get back to my screen here, they disagreed. Okay, so this is a relatively conservative court, which is important for us, because if you were in a more liberal court, I can almost guarantee they'll come up with the same answer here. But this is Florida, kind of more of a conservative area. And they said, no, we don't think these employees are exempt. They didn't have any authority to make higher level business decisions. They didn't have the authority to negotiate settlements or recommend litigation against whoever might be liable for the damage to the broadband systems. And they couldn't shape company policy. They said, hey, these employees are not performing work directly related to management or general business operations. Now, I'm going to Saturday morning quarterback or whatever, Sunday morning quarterback, what do you call it? I don't know. I don't watch football. I shouldn't say that in Pittsburgh. In any event, they said these are akin to production employees. So these are the same things as the guys who make widgets on the production line. They're just carrying out their employer's core business, looking at property damage. I'm not completely sure that I agree that these folks are not involved with the general business operations, maybe not management, but general business operations. I am not sure that if I had looked at this eons ago when I practiced, that I would have come to the conclusion that these folks were non-exempt, but that's what the court came to the conclusion of. What's our sort of takeaway from this? Well, it's interesting that the court found this because oftentimes administrative exemption employees, they don't have much management discretion or duties or responsibilities. And this court is kind of setting a pretty high bar, because I would have thought that somebody who goes out and assesses a claim like this would probably be exempt, because I would assume that each claim is unique. This is such a unique business that it would take a lot of independent discretion and judgment and some level of authority to say, hey, this claim I think is worth $1 million, and this claim I think is worth 500,000 or whatever, even if they didn't have the management authority to say, I'm going to go and negotiate a settlement over this damage. To me, this is a surprising result, but that is the case law that we have to work with. So our takeaway is sort of not enough to just have general business operations that they're doing. They have to have a pretty high level of management authority as well. Okay, moving along here. Let me go back over to my screen here to see if anybody else has commented. Okay, so somebody else made a great comment here. I think that they are not exempt because they probably have guidelines they must follow. It would not be 100% independent discretion and judgment. So that is a great comment with respect to insurance adjusters. That comes up all the time as to whether insurance adjusters are exempt or non-exempt. And those of you who've heard me speak before, I've talked about insurance adjusters because part of the country thinks that they are exempt and part of the country thinks they aren't exempt, depending on which court system you're in, for that very reason. You know, if I wrecked my car, let's say I was backing out my driveway and hit my retaining wall. Not that that's ever happened. Don't tell my husband. Do they just look at a manual and say, well, gosh, Ann scraped the side of her car, and we know that a panel on XYZ model costs this much, and how much discretion and judgment is that? That's a problem, because we have a split in the courts on whether insurance adjusters are exempt or not for that very reason. Are they just following a manual? And when we look at the case, Fowler, they weren't following a manual at all, because it wasn't like they had, hey, these BMWs get this and these Hondas get this. These were all unique situations. And if they didn't have enough management authority there, it makes me wonder how any insurance adjuster has enough management authority, because they are following pretty set guidelines for assessing a claim. Okay, let's move on here. Marcus versus American Contract Bridge League. This is out of the First Circuit, which is Massachusetts and up in the Northeast. No, these aren't the bridges that you see in Pittsburgh. This is the card game, okay? So delve back into a few decades ago when this was really popular. Apparently, it's still popular among some. I have played bridge, and it really does take a lot of strategy. I was not good at it. In any event, this is an organization, a national organization that sets up tournaments. They also offer mentoring to help folks who struggle with their game or want to gain better strategy. So they employed folks in the following categories: tournament director, national tournament director, associate national tournament director, field supervisor, area manager, and mentor. Now, just looking at those titles, I would have formed some opinion in my mind as to who's probably going to be exempt. Now, title is not determinative, obviously, But when I hear national tournament director, I'm thinking, gosh, that's like the head honcho, right? When they have these bridge games, that's the person who's doing it, right? So my little guess in my mind would have been, hey, that person's going to be exempt for sure. And when we look at what the district court said, they found that everybody except the tournament director was exempt. Okay. They essentially said, hey, they're managing the tournaments and the associated staff. They're training other directors and making rulings. They're scheduling, they're guiding disputes. They would have the authority that apparently if there's a dispute among the bridge players, that they would have the authority to resolve it during the tournament. They obviously did non-manual work, and they had significant sort of independent discretion and judgment. You know, obviously the national tournament director, when he or she was at the tournament, was the head honcho. They were the final word. Same thing with any of the tournament directors. They were the final word. So the district court says, hey, these folks are exempt. And do we think they are exempt? So we'll go back to the one person's answer that we wouldn't be talking about this if they were all exempt. But this got appealed, of course. And the circuit court, which is a more liberal court, it's up, again, Northeast, said, hey, we agree with you on some of these. The primary duty of the positions was not directly related to the management or business of some of them, because the primary duty of the employees in those positions was to supervise bridge contests, and thus they were responsible for providing the very service that they're in the business of doing. They said, hey, we think the field supervisors, area managers, and mentors are exempt. Does that surprise anyone? I would have thought the mentors would not be exempt, because going to the person's comment who said, hey, they're just going by guidelines, I would have thought the same would be true about bridge mentors. There's rules to the game. You go by the rules of the game. There's certain strategies. I'm sure you could go to the library and get a book on how to play bridge. There's certain strategies as to how you do that. And we're sort of just passing this along. Now, the one thing I want to point out here, this employer did not argue this. But when I read in the case that they were responsible for overseeing other employees, does that sound like the executive exemption to anybody? I'm not sure why the employer did not argue that. And that's something that's really important to keep in mind when you look at these gray area employees. We can classify them as exempt based on all three exemptions if we want, with the idea that if one fails, if we fail under the administrative exemption, which maybe we think is our strongest argument, we've got the executive one perhaps to back us up, or the professional, or whatever. So when you look at job descriptions, if you're putting in there this person is administratively exempt or is exempt under the executive exemption or whatever, you may want to look at those job descriptions and say, hey, we're going to broaden this. It's like a strategy, right? They're exempt. And we've done an analysis under the executive exemption and the administrative, and they're exempt under either way. That's perfectly acceptable to do. You can say somebody's exempt under two of the exemptions, and that way, if one of them fails, you have a backup. Okay. However, the circuit court said that the national tournament directors and the associate national tournament directors were not exempt. So basically all of the tournament directors, right, from the tournament director position to the national tournament director position to the associate national tournament director, were all non-exempt. Now, I have to tell you, that surprises me as well. You know, I mentioned if I just looked at the job descriptions, I would think somebody that runs the national tournament would be exempt, because they would have so much independent discretion and judgment, so much authority, because they were the final say at these tournaments, that they would be exempt. But the court said, maybe not. We're not sure. We don't think so, though. That to me is a surprising result, but it again shows we have a conservative court decision out of the 11th Circuit. We have a more liberal court decision out of the First Circuit here, both recent decisions, and both are putting that bar of management authority really high. Who else in this organization is going to be higher than the national tournament director at the national tournament? I've never attended one of these, but I think that is a bar that most employers, if you analogize their management structure to your company, that's a really high bar that most employers can't meet. Okay. Moving on, this is our circuit if you're here in Pennsylvania. So we've seen a really high bar. This case is a little bit older, but it's still good law. What did our circuit say in Pennsylvania, and why did they say it? So Smith versus Johnson & Johnson, people recognize, I'm sure, Johnson & Johnson. She was a pharmaceutical sales representative. She went to doctors' offices and said, hey, look at our products. The employer deemed her to be exempt. She set her own schedule, the order in which she visited folks, and she worked primarily out of her home. She testified that like 95% of her time, she never basically saw anybody from her company. No supervision at all. The district court found her to be exempt. What do we think the circuit court did? Okay, this is a trick question. Do we think she is exempt or not? Well, interestingly enough, circuit court agreed with the district court. And some of you may be scratching your heads and saying, none of these courts make any sense. And I can identify with that, having dealt with the court system for 25 years. But here is the trick or the twist on this one. They said, hey, yeah, I think she's got managerial qualities of her position because the order and number of visits made to doctors was left to her discretion. How do we reconcile this with the Fowler OSP case or the American Bridge case, which seem to require a much higher level of managerial duties? Well, the trick here is there's a U.S. Department of Labor opinion letter that opines that pharmaceutical sales reps are exempt. It's an older letter. Why the DOL opined that is, I'm not sure, because if I look at the other cases, I would say this person does not have sufficient managerial discretion. However, the court gave great deference to that DOL opinion letter. And in 2011, in almost an identical case, the U.S. Supreme Court agreed on a different pharmaceutical sales rep situation. This is a lesson, I think, to all employers that it can be really helpful to involve legal counsel. And again, I don't practice anymore. I'm not legal counsel. But if you have somebody who's a gray area, there's lots of DOL opinion letters out there. Sometimes there's interesting regulations that for whatever reason, maybe good lobbying, I don't know. The DOL has issued a regulation or an opinion letter that is extremely helpful and sort of saves your hind end whenever the facts of the case don't look like the person should be an administrative exemption. So the takeaway from this is it is in opposite to the other cases. Those cases don't support this decision, but when we have a gray area employee, it's worth taking a look at DOL opinion letters to see, hey, is there something out there that we can hang our hat on to save ourselves? This is another great example. Johnson & Johnson probably doesn't need insurance for the claim, but if you were the employer, you can never stop a lawsuit, right? You just can't. You know, people used to come to me and be like, well, it's a frivolous lawsuit. Can't we stop it? No, that's impossible. We have free access to the court systems, basically, but it costs you a lot of money to defend. And even if you win, you can lose because of the amount you pay in attorney's fees. That's another reason, like this one, if this had been a smaller company, to say, hey, we have insurance to cover the attorney's fees. And if we win, we're out our deductible and a headache of having the litigation, but we got to defend ourselves. We got to have our day in court. And in this case, they won without any damages. So something to keep in mind. All right, is everybody feeling good about the administrative exemption? You can chime in on the little Q&A. All right, let's move on to the professional exemption. So this one, we are not touching on the creative professional exemption today. That's like artists, sculptors, people like that. It can be museum curators sometime. That, because that's not a very common one. We're looking at the learned professional exemption. Again, just briefly to go over it, you have to be paid a salary. Again, 684 right now, likely to go up above 1,000 here shortly. The primary duty, just like the primary duty, there is a test for the administrative employees. The primary duty for professionals, it requires advanced knowledge, usually through some type of additional degree. They don't actually define what that additional degree or that additional advanced knowledge is. It usually has to be intellectual in character. And again, you have to have independent discretion and judgment. So we have some requirement here that our primary duty is advanced knowledge through some type of specialized course, prolonged specialized course, but again, they don't say how long. It's typically in a field of science or learning. Isn't that a broad brushstroke of a word to say, what is that? The obvious examples for professional are doctors and lawyers, right? They're always or almost always exempt. But let's talk about some other people here. We got the Ninth Circuit. You can't get more liberal than the Ninth Circuit. They're California, Washington, Oregon. That's the West Coast. So we have a situation here. The employees were social workers. All right, this is time to make sure everybody's still awake and that I haven't bored everybody to tears yet. Social workers, are they going to be exempt or not? What do we think? Anyone? Bueller? Please chime in. Let me know what you think. So they required a 4-year college degree. That college degree could only be in certain subjects. So anthropology, education, criminal justice, or gerontology, or obviously social work. The employer, which was actually the state of Washington, it was their Department of Human Services, said, hey, we work with a diverse population, right? We work with everything from we're removing children from homes to the elderly. And it makes sense. We also work in the criminal justice system. It makes sense that we need people with slightly different degrees and specialties to be exempt or to work in our position. Okay, everyone is saying, no, they are not exempt. Okay, one person says they should be. If that person wants to chime in as to why they think they should be, I would love to hear your thoughts on that. So the Washington Department of Human Services basically said, hey, they're learned professionals. They've had at least 4 years of education in something related to the work we do. They also had to have some experience. We'll talk about that in a second. But they require like 18 months of experience, something along those lines. And, you know, they're doing the work they do, and they do have independent discretion and judgment because when they're out in the field, they're making some decisions for the children or for the elderly or whoever they're working with when they're out in the field by themselves. So the district court agreed, right? We've got a district court, again, in a very liberal, which is, and when I use liberal, I trust me, I stay away from politics. Liberal in my sense usually means employee friendly. So we've got a very employee friendly court that said, hey, we agree. They have the learned professional. They have 4 years of experience, plus they had to have like 18 months. I'm sorry, 4 years of education plus like 18 months of experience. They're exempt. What did the Ninth Circuit say? If I can get my little cursor back over here. 1 second, folks, as I struggle with technology. They disagreed. Okay, so the Ninth Circuit had several problems with this. They said, hey, the areas of the degree are too diverse, essentially, and not necessarily directly related to the work. So it has to be specialized intellectual instruction. And the court essentially said, hey, you didn't require a social work degree, right? You can get a social work degree. You took degrees from various fields that are out there. And of course, Washington State is sitting there arguing and saying, hey, we do all that work. we deal with the elderly. It makes sense to have somebody with a gerontology background. The court also took issue, and this was interesting, that these social workers had to undergo a 6-week on-the-job training. The court essentially said, if you're a professional, you should be able to hit the ground running. You shouldn't need a training session. All right, I don't know about you, but let me go back 25 years to when I graduated law school. I was knee-high to a grasshopper. I may have had 2 degrees under my belt, but did I know what I was doing? So anybody who may have been a client at the firm when I was that age, you didn't hear this. But no, seriously, doesn't everybody need some mentoring or training? Do we hit the ground running just because we graduated from college or a master's degree or whatever it might be? I think that's a very troubling statement by the court to find that on-the-job training is a strike against you. It's not determinative, but it's a strike against you on the professional exemption, because just because I graduated from law school doesn't mean I knew the ins and outs of how, say, the Allegheny County Courthouse did business. I didn't. I came from a different state even. I had no idea. I think that's a really troubling factor that they weigh, but they did weigh that factor, so employers should be aware of that. The circuit court also said, hey, 18 months of social work experience, which was a requirement in addition to the education, is irrelevant, because under the professional exemption, you will never get the professional exemption just based on having someone who has work experience. Maybe my work experience might be better than the newbie who just graduated law school or who just graduated from social work college. But if I don't have that degree, you're dead in the water with a professional exemption. So that's something to really think about. So our takeaways here are, one, they're going to look for a degree that's highly specialized, right? They're going to look for not on-the-job training. If that's your argument, it's not going to work. You might, to our comments earlier, fit under the administrative or maybe even the executive exemption, but you're not going to succeed here. And then keep in mind that any training program, and I'm not saying jettison your training programs, I don't think you should. Just keep in mind that that could be held against you. And I think that's something you should look at and say, well, gosh, we need that. And we would justify the training program to say, we're doing maybe in Ann's case, things that are specific to Allegheny County. It's not that she needs a refresher from law school. She just graduated, but she doesn't know how to, the actual mechanisms of the Allegheny Courthouse or something like that. Interestingly, if you're in the Western District of Pennsylvania, we have an almost identical case. And by the way, the Western District of Pennsylvania is the lowest federal court here in Pittsburgh. They also cover Erie County. They cover basically everything over to almost Harrisburg, where a group of social workers has filed a claim saying, hey, we are not exempt. They're case managers, family resource specialists, ongoing case specialists. They claim their duties of collecting data and coordinating client care are not exempt, and therefore they're owed overtime. This case is still meandering through the court system. I could not find any resolution of it other than it had been filed in 2021. It was denied what we call class action certification. So these employees are going sort of individually, which hurts them. But this case appears to be winding through. And in any event, they were looking at whether or not they were administratively exempt. But the other argument, because this is an either or, right? We can have multiple exemptions, is that all of them had to have a BA or an MA in social work. So they're also looking at whether the professional exemption, since they more narrowly tailored the degree that is required for this job, is going to help them get a different result than what the Ninth Circuit had. So ongoing, but it's interesting to see that, the issues are the same the world over in a certain sense, that what you see happening in California is the same as here or Washington State. And these issues come up all the time because we have, again, an employer who said, well, these folks are exempt because A, we think they're administratively exempt, or B, we think they're professionally exempt because we have narrowly tailored degrees for them. Okay, nurses. This is when you chime in again. Are they exempt? right? They have to obtain a nursing degree. I certainly hope somebody without a degree is not working on me. They have to take boards and have a state license. All the nursing schools basically do require an on-the-job experience or internship before graduating. But do you know any nurse in Pittsburgh or wherever you're located that's exempt? So what do we think here? And let me get my little thing over to where it belongs. Okay, everybody's saying not exempt to the nurses here. Is that because we don't know any nurses who are exempt, or do we think we could ever make them exempt? So this is a really interesting one. By tradition, nurses are not exempt, right? The way that we, for whatever reason, as a society, have hired them and paid them, we have made them non-exempt. But we've got a DOL fact sheet here that says differently. So the U.S. Department of Labor, and they have divided the nurses into different categories, has said, hey, we recognize that nurses are typically paid on an hourly basis. That ruins any exemption. But if you paid them on a salary basis, they would be exempt, at least the RNs would be, because they have a specialized degree, independent discretion and judgment. We think they would be exempt. That is a really interesting letter by the Department of Labor that says, hey, at least with our sort of higher level nurses, RN, BSN, they're going to be exempt because of the specialized degree, because of the independent discretion and judgment. It's just that you employers don't pay them on a salary basis. If you wanted to flip that, they could be exempt. I'm not sure that any nurse, because of the tradition that's built in, would work on a salary basis, but it is an option. But your LPNs, your patient care techs, they are not going to be exempt because they don't have enough of a specialized learning degree to do that. Does that surprise anyone? Or everybody's tuning me out and doesn't care? That's okay too. I'm used to that with my kids. Yeah. Okay, so somebody actually said our nurses are exempt. Yeah, if you pay them on a salary basis, the RNs, the BSNs, they are exempt, and you have a wonderful DOL opinion letter to hang your hat on. Other people have said, I don't know any exempt nurses. Again, that's a bit of a tradition, particularly here, because this is my knowledge base. Where I worked, we represented just about every major hospital in Pittsburgh, and none of them were doing, unless you got to like a supervisor level, exempt nurses. And that's just because of the way they paid them. And paying salary can cut both ways, right? You have to decide whether that's good for your business or not. But in any event, that is certainly something to think about if you're in healthcare. All right, one more. Dietitians and RNs, all paid on a salary basis. So we just said there's a DOL opinion letter out there. This is the Southern District of California, so a lower court out in a liberal jurisdiction. In any event, the district court said the RNs are not exempt. That to me is very troubling because that goes against the opinion letter, but that's where the court came down. They said the dietitians are exempt. Why? Well, no, I don't mean why did you pick HR as a profession, and why did we get this court result? Never forget state law. Okay, so this is a twist here as well. It's to have a little twist, make it fun. Yes, I know you're all thinking if this is my idea of fun, I need to get a life, but there's a state regulation in California that says RNs cannot be exempt. So that's why we got a different result. And that's an important lesson for us, because every state has their own, or almost every state has their own wage and hour laws that talk about classifications. And they all have quirks to them that are different than the FLSA. In Pennsylvania, one of the biggest quirks we have with respect to classification, we don't recognize the FLSA computer professional exemption. I won't get into all of that, but just know that if you're in Pennsylvania, we have quirks that don't match up with the FLSA on classification, on how you pay, on different things like that. And that can result in a surprising outcome that you wouldn't anticipate under the FLSA, just like this case. So moving along, because I know we're running short on time here, the executive exemption. Again, we're not going to go into detail, but essentially you got the salary basis, They have to be managing part of the enterprise or a subdivision of it. They have to regularly direct the work of at least 2 or more full-time employees. Yes, you can add part-time employees together to get full-time employees. They have to have the authority to hire, fire, discipline, etc., or at least significant input into that. So this is where your managers, this is often the backup exemption with administrative employees, or you say, hey, they fall under both. To do that, we've got Jones versus Williams, which is out of the District Court of Maryland, so very close to us. And essentially, we had an employee who was a police supervisor with the rank of lieutenant. And he's responsible for essentially, making shift assignments, reviewing paperwork, responding to calls if needed. But he's also responsible for doing some of the work that the people he supervises do, right? Like ensuring campus safety, setting up traffic barrels, doing snowstorm duty, where apparently he incurred a ton of overtime. The employer sought what is called summary judgment. And this is a really critical legal concept, and I don't want to bore everybody to tears here. But when we evaluate a case, if you're talking with your counsel and we're saying, what is our exposure here? One of the things we look at is whether or not we think we can get the case out on what's called summary judgment, which means, hey, even if you accept everything that the employee says is true, which is the legal basis for getting the case out. Sure, believe everything he says. We have a legal argument that says we still win, and therefore, court, you can kick this case out of the court system. Now, at this point, you've already spent, $100,000 on attorney's fees, but at least you're not going to go to trial, and you're not going to take the risk of a jury verdict, and you're not going to have to appeal, et cetera, et cetera. So in any event, the employer sought summary judgment, which the court denied. And the court said, hey, this isn't a legal test here. This is a factual test as to what his primary duty was, because there's different testimony here as to how much of his time was spent doing the scheduling, overseeing the employees. There was no doubt he had more than 2 employees under him. And there's a question as to what his primary duty is. We don't know what the outcome is here. A lot of times when summary judgment is not granted, the case settles out. But it's an important takeaway for us to say, hey, if we know we can't get out on summary judgment, we know this case is a lot more expensive, and we know that the primary duty with respect to the professional exemption can be open to a factual dispute that a jury will decide against us. We have here a very similar case that's out of the 10th Circuit. It was a private security company, but they had the same hierarchical structure that the police department did, where you had lieutenants, captains, majors, whatever. Same idea. They were providing security for Los Alamos National Laboratory. And they had workers who are non-exempt called SOs and SPOs, sort of like the police officers, your foot patrol guys or gals. And those were clearly non-exempt. But we had lieutenants who said, hey, yeah, if there's an alarm, I'm also responsible for responding. And yeah, I oversee and coordinate emergency personnel and workers and stuff, but I do some of their same duties. Then we had captains who said, hey, I oversee at least 15 SPOs and 3 lieutenants. Do we think they're exempt? Right? We already know that the lieutenants may have an issue based on the other decision. But what about the captains? You guys can chime in if you want. Or if everybody's already left for lunch, that's okay too. The district court found all of the supervisors to be exempt, either under the executive or the administrative, which again shows the strategy of if we have a gray area employee, maybe we go for 2 exemptions. But what did the circuit court say? So the circuit court said, hey, no one is exempt. Even the captains. Does that surprise anybody? I find that surprising. I think the captains supervise enough people and spend enough of their time that primary duty should have been satisfied from a legal basis as to whether or not they're exempt under the executive exemption, but they said, no, it's not. And part of this decision hinged on an FLSA regulation that essentially says almost all first responders are non-exempt. by law. So there's a little quirk to this case, but it's something to keep in mind that this court, again, is setting a really high bar, like they did with the administrative cases, to say, look, not sure if this is going to qualify as the executive exemption or not. All right, some takeaways up before we all go to lunch here. These were all close calls, but that's always your problem area. And really and truly, as we saw, the district courts often decided in a way that was different than the circuit courts. You've got learned judges that come down with different opinions on this. And like I said, with the insurance adjusters, depending on where you're at in the country, they may or may not be exempt because different courts view this different ways. Obviously, I think you should ask legal counsel if you've got a gray area employee. One of the beauties of talking to legal counsel is the attorney-client privilege, so that you can discuss the pros and cons of what might make your employee exempt or non-exempt, and know that that's cloaked in the attorney-client privilege. So if you say, well, hey, we got this going for us, but we also know this is a problem, it's a great way to cloak that discussion and get some input. And again, I'm a big fan of talking to somebody who specialized in labor and employment, even though they're more money than your general practitioner, because they've been around the block, they've seen the DOL, they've argued in front of the DOL, whatever it may be. Be aware of state-specific regulations and issues, especially with remote workers. We've talked about this before, but remote workers are concerned because it's the state law where they're located, not the state law where you're located. So if you had an RN out in California, they may be exempt here in Pennsylvania if you pay a salary basis. But because of that quirky state regulation in California, they're not exempt. Consider overlapping exemptions. I think that's a huge and good strategy to sort of document that and say, hey, we looked at this from a number of ways, and we think this person could qualify for either exemption or all three exemptions or whatever it is. What if we still come down to the fact that we've got a gray area? Well, the first thing, we are a business, right? We need to know what our exposure is if we keep them exempt. And so we have to have an idea of the hours, and we'll talk about whether we make them track hours, but we have to know approximately what the hours of overtime are, times the number of employees that we have. That's our minimum exposure for 3 years, plus interest and penalties. If we only have one employee and we say, gosh, they almost never work overtime, I'm willing to take the risk because even if we got called on the carpet, maybe it's $5,000 and we just pay it. But you have to know what your risk is when you're making this decision. One thing you can also do, because one of the biggest problems here is we may say, hey, we have an employee who almost never works overtime. And we firmly believe that, maybe 2 hours a year they work overtime. Oftentimes, when that employee leaves or files one of these actions, they're unhappy for whatever reason. And this is just part of it. And their perception of how much overtime they worked is very different from yours. It's not 2 hours a year. You may be wrong about that, or you may be right and the employee's just very upset. They worked 100 hours every week, according to them. If you make, and you can make an exempt employee track their hours, or you can help them track it. I always like the employee tracking it because then it's in their handwriting, so to speak. Even if it's on the computer, they're the ones inputting it. And they should not be lying to us about the time they work. We can make an exempt employee keep track of their hours. That way, if we get called on the carpet about them, we have a time record, because usually you don't have time records with employees in this situation. That's a cultural thing, though. A lot of exempt employees object to keeping a time record. So that's something to weigh, but it is an option for you. If you say, gosh, we're worried about this, we want to minimize our risk, that is something you can do. So that if you get into an issue and the DOL says, hey, you owe overtime, you have a record to show the hours actually worked in the guy or gal's handwriting or inputted by them into the computer to say this is what it is or isn't. All right, that wraps us up just in time for lunch here today. I know court cases can be dry, but I appreciate everybody hanging in there. If anybody has any questions, please feel free to ask, and I will hang on here a second to see if there's any questions. Hopefully this was helpful to everybody. Okay, we do have a question here. with a CFO, so Chief Financial Officer, or VP of Finance, Controller, and Accountant, are all exempt or just the higher levels? I think that's the question. And thank you to the people that said thank you. You're quite welcome. I really enjoy this, and I wish I was a little better with technology. But please come to our Please come to our seminar in April. I think it's April 18th. The PNC facility is really, really nice, and there's going to be food. There's me too. You have to put up with me, but it'll be fun. So, but let me answer this question. So, great question here, because we're distinguishing between different job levels: CFO, VP of Finance, and Controller, and Accountant. So, accountants can be exempt. I would say the CFO, VP of Finance, and Controller are likely to be exempt, right? They're usually, presuming under the professional exemption, they all have 4-year degrees in accounting or finance or something along those lines. Assuming we pay them a salary basis of at least $684, which is likely to go up above 1,000 here very shortly, they're likely to be exempt under the professional exemption. They're also likely to be exempt under the executive exemption. I will bet, like the CFO, he or she is in charge of the VP of Finance, the Controller, and the accountants. They're likely to qualify under the executive exemption again. The accountant is the one that's a question mark, and they often fall into a gray area. They will likely have, I hope, the 4-year degree. Bookkeepers are almost never exempt because they don't have that 4-year degree and they don't have sufficient independent discretion. They're essentially just a bean counter who's recording things in whatever computer system you have. But the accountants are the gray area. I don't know from here if this person supervises anybody and we could get them in under another exemption, but the accountant probably has a 4-year degree. Whether or not he or she has sufficient independent discretion and judgment is up for debate. And we really have to look at more facts to know whether or not we could get that person into the the professional exemption, or one of the other exemptions could be available to them too. It's just not enough facts from this question to know. But I hope that helps you a little bit, at least guide you as to where it might be. Let me see if there's anything else here. Okay, everybody is very welcome. Again, happy early St. Patrick's Day. Very important to celebrate. Enjoy the weekend, and hopefully I will see you in April. Take care, everyone.